compromise. He was interrogated by the bank's audit team and later by the police. Claimant contended that he was suspended immediately upon release from police custody on the 11th day of June 2020. The claimant alleged prejudgment by the bank, which treated him as a common criminal. Claimant stated that he was suspended without pay for 6 months before being dismissed on the 17th day of November 2021. Claimant stated further that the bank acted in bad faith, filed police petitions prematurely, withheld salaries unjustly, and ignored lack of direct evidence of fraud. The case of the defendant is that the defendant, by leave of court, filed its statement of defense and other processes against the suit, wherein contending in summary that the claimant was employed as a banking officer under a probationary letter dated 11th day of December 2018 and subsequently confirmed on the 14th of August 2019. Defendant stated further that the claimant's username and password were linked to fraudulent activities resulting in losses amounting to 32,650,000 naira from customer accounts with the unauthorized change of customer phone numbers on the 4th day of October 2020 to enable USSD-based fraud of fund transfers / airtime purchases. Defendants stated that the fraud persisted for 8 months until 14th of May 2021 when detected by a customer. The claimant was absent without authorization and later interrogated by the bank's audit team and was then issued a query. As a result, having admitted sharing his password with colleagues, to which violated the bank's information security policy. A disciplinary hearing was held on the 27th day of August 2021. During the session, the claimant represented himself, and upon the conclusion of the hearing, the claimant was summarily dismissed on the 3rd day of November 2021 for gross misconduct and password compromise expressly prohibited under the bank policy directly linked to financial / reputational harm. His team members, Victor Onyeka and Ibrahim Ogunsanya, were also dismissed for same violation. The defendant relied on the principle of voluntary non-fit injuria and says that the dismissal followed due process. The defendant's counterclaim. Defendant's counterclaim against the claimant and defendant's counterclaims against the claimant and sought for relief as follows. A, an order of this honorable court declaring that the compromise of password by the defendant to counterclaim is an act of gross misconduct which resulted into the loss of 32,650,000 from the accounts of some customers of the counterclaimant. B, an order of this honorable court declaring that the fraud which occurred as a result of the defendant to counterclaimant's gross misconduct by way of compromising his username and password, which led to the loss of 32,650,000 naira from the accounts of some of the counterclaimant's customers, caused reputational damage to the counterclaimant. C, an order of this honorable court declaring that the defendant to the counterclaim is liable to repay the counterclaimant the sum of 32,650,000 naira expended to settle the counterclaimant's aggrieved customers. D, an order of this honorable court awarding the sum of 10 million naira against the defendant to counterclaim in favor of the counterclaim as general damages, in favor of the counterclaimant as general damages for breach of contract as a result of the defendant to counterclaims gross misconduct which led to the fraudulent withdrawal of the sum of 32,650,000 naira from the accounts of some customers of the counterclaimant. An order of this honorable court awarding the sum of 20 million naira against the defendant to counterclaim in favor of the counterclaimant as general damages, as special damages for the reputational damage caused by the defendant to counterclaim when he compromised his password, which led to the loss of 32,650,000 naira from the account of some of the counterclaimant's customers, some of whom had since moved their monies and closed all their accounts with the claimant. F, an order of this honorable court awarding the cost of 5 million naira against the defendant to counterclaim in favor of the claim of the counterclaimant for the legal fee and prosecution of the counterclaim. Reply to the defendant's statement of defense and defense to counterclaim. The claimant, by leave of court, filed and served a reply to the defendant's statement of defense and defense to the counterclaim dated 6 July 2023, but filed on the 12th day of July 2023, by which the claimant responded by admitting or denying the facts pleaded by the defendant. Basically, the claimant restated in reply the facts in his statement of facts and maintained same facts in his reply to the statement of defense as his defense to the counterclaim. This was accompanied with the claimant's further testimony on oath sworn to on the 13th day of July 2023. Trial. Trial in this case commenced on the 20th day of January 2025. Wherefore, claimant, in the course of his testimony as CW1, adopted his two witness statements on oath sworn to on the first day of July 2023. In the course, tendered documents in evidence which were marked as follows. One, letter of confirmation dated 23rd day of September 2014, Exhibit C2, Fidelity Bank commendation letter dated 19 September 2016, Exhibit C3, letter of employment from Nove Merchant Bank dated 18th of October 2016, Exhibit C4, Wema Bank offer of employment dated 11th December 2018, Exhibit C5, Wema Bank letter of confirmation dated 14th August 2019, Exhibit C6, letter of dismissal from Wema Bank dated 17th November 2021, Exhibit C7, 3 certificates of training dated 22nd September 2017. The other one is 28th September 2017, and that of 15th of September 2017, Exhibit C8 to C10, respectively. CW1 was thereafter cross-examined by the counsel for the defendant, and there being no examination and no more witness to call again, the case of the claimant was then closed. Defendant opened its case and called its sole witness, Kende Buhari, who testified and adopted his written statement on oath deposed to on the 22nd May 2023 and tendered the following documents in evidence which were marked as exhibits WB1B to 6, WB1B to C, WB2, WB3, WB4, WB5, B6, WB7, WB8, WB10, WB11, WB12, WB13, and WB14 respectively. DW1 was cross-examined by learned counsel for the claimant, and there was no re-examination. The case of the claimant was the case of the defendant was then closed. Defendant's final written address. In compliance with the rules of this honorable court, parties were ordered to file their written addresses. In this regard, the defendant filed its final written address on the 14th of March 2025 and submitted 2 issues for determination to it: A, whether the summary dismissal of the claimant after his suspension without pay by the defendant is legal and lawful; B, whether the claimant is entitled to any of the relief sought on his statement of facts and the general form of complaint, or the defendant / counterclaimant is entitled to any of the relief sought on its counterclaim. Issue 1. Learned counsel submitted on issue 1, re-emphasizing on the general position of the law regarding employers' power to suspend without pay. Counsel posited that it is a temporary disciplinary measure depriving an employee of work privileges pending investigation. Counsel referred the court to the case of University of Calabar against Isiaga, citation provided. Counsel further posited that suspension holds the employment contract, including wages, and cited the case of Longe against First Bank of Nigeria PLC, citation provided as per Salami JCA, as then he was, where it was held that in court suspension of an employee is also the suspension and cessation of the employee's contract of employment, as well as the rights and privileges, duties and responsibilities attached to his position, end of quote. Counsel further submitted that suspension facilities unhindered investigations and relied on the case of Lewis against Heifer, citation provided, where the opinion of Lord Denny Neymar in this case was expressed that suspension may be a way of good administration which facilitates the conduct of inquiry into the allegation made against the person suspended, end of court. Counsel referred the court to Shell Petroleum against Omu, citation provided, where it was held that courts cannot fetter an employer's right to discipline. Also, in the case of Imonike against Unity Bank, citation provided, where it was held that suspension is a lawful disciplinary tool by an employer on an erring employee, as the employer has the right to discipline the employee in the interest of the organization. Learned counsel submitted that the reasons for claimant's suspension and dismissal were for fraudulent activities. The claimant's username / password were linked to fraudulent transfers of sums amounting to 32,650,000 naira from customer accounts. The fraud involved changing customers' phone numbers to bypass alerts during the period of the 4th of October 2020 to 14th of May 2021. Counsel submitted that the claimant shared his password with colleagues, thereby violating the bank's information security policy exhibits WB2, WB3, WB15. Counsel further submitted that the claimant was issued a query as in Exhibit DX1 and faced a disciplinary hearing on the 27th of August 2021. He was dismissed on the 17th of November 2021 for gross misconduct as per Exhibit C7. It is therefore the submission of counsel that the employer has the right to dismiss summarily, and posited that the gross misconduct by the claimant justifies his dismissal. What the claimant did was said and defined employer-employee trust. Counsel cited the case of Uzondu against UBN PLC, citation provided. Also, counsel noted that the passport compromise qualifies as gross misconduct. Counsel submitted further while referring to Sule against Nigerian Customs Board, citation provided, where it was held that disobedience of lawful orders warrants dismissal. Counsel is of the opinion that the defendant complied with the due process and fair hearing based fair hearing based assessment on the fact that defendant having given query to the claimant, he was heard by a disciplinary committee which allowed the claimant to defend himself. Counsel cited the case of Momo against CBN. Counsel further submitted that no oral hearing was required, hence written responses suffice. Counsel cited the case of Olatobusun and against NISA Council, citation provided. Counsel maintained that the claimant admitted to password sharing, but argued that the dismissal was excessive and instead suggested resignation. On issue 2, counsel submitted on issue 2 while canvassing his arguments against claimant's reliefs, in particular reliefs A and B, are for wrongful dismissal declarations. The claimant seeks a declaration that his dismissal was wrongful, oppressive, and unfair, alleging he was not given a fair opportunity to defend himself. The defendants rebutted this and stated that his dismissal was lawful, valid, and followed due process based on the disciplinary hearing procedure that was conducted on the 27th of August 2021. Counsel cited the cases of S&D Construction Company Limited against Ayoku, and another citation provided Ogunsanya against the state, citation provided, among other cases. Counsel submitted that the claimant admitted to password compromise violating bank policy as in exhibits WB2, WB15, also the fraudulent losses of 32,650,000 naira was directly linked to his negligence. It is the submission of counsel or relief C and D, which is damages and the legal costs estimated at 20 million naira. The claimant seeks this as aggravated / exemplary damages and litigation costs. The defendant rebutted this, that there was no basis for damages since dismissal was justified. There is no evidence of wrongful termination given to support these claims, and in this regard, this court was urged to discountenance these reliefs and based on the established misconduct of the claimant that caused financial / reputational harm, dismiss all the reliefs. Submissions with regards to the counterclaim. Learned counsel submitted that the defendant seeks for 6 reliefs due to the claimant's gross misconduct. These: 1, declaration that the compromise of password by the defendant to counterclaim is an act of gross misconduct which resulted into the loss of 32,650,000 naira from the accounts of some customers or the counterclaimant. 2, declaration that the fraud which occurred as a result of the defendant to counterclaimant's gross misconduct by way of compromising his username and password, which led to the loss of 32,650,000 naira from the accounts of some of the counterclaimant's customers, caused reputational damage to the counterclaimant. 3, an order of court declaring that the defendant to counterclaim is liable to repay the counterclaimant the sum of 32,650,000 naira expended to settle the counterclaimant's aggrieved customers. 4, general damages to be awarded against the defendant to counterclaim in the sum of 10 million naira for breach of contract arising from his gross misconduct and led to fraudulent withdrawal of the sum of 32,650,000 naira from the accounts of some customers of the counterclaimant. 5, special damages of 20 million naira for reputational damages caused that led to the loss of 32,650,000 withdrawn from the accounts of customers, some of whom had since moved their monies and closed all their accounts with the counterclaimant. 6, legal costs of 5 million naira for prosecution of the counterclaim. Counsel further submitted that general damages are presumed from wrongful acts, need not be strictly proven. Counsel referred the court to the case of 7-Up Bottling Company against Nkanga. Counsel contended that reputational harm is compensable in tort and contract laws. Counsel cited the case of Mrs. Antonia Agbasi against Jerome Bem Bula citation provided. It is the submission of counsel that under employee liability, where misconduct causes financial loss, employer can seek restitution and place reliance on the case of Grema Wawa against FCMB PLC citation provided. Learned counsel submitted that the claimant's case lacks merit and that dismissal was justified per bank policy and evidence. Counsel maintained that the defendant's counterclaims are substantiated, that financial losses of 32,650,000 naira directly tied to claimant's actions. Counsel submitted that the reputational damage and the legal costs warrant compensation. Counsel then urged this honorable court to dismiss the claimant's suit and grant defendant's counterclaims in full. Claimant's final written address. Claimant's filed his final written address on the 25th day of April 2025 and submitted the following issues for determination to it. 1, whether in light of the evidence, the claimant has made a case for setting aside the dismissal of the claimants by the defendant for being wrongful, unfair labor practice, and contrary to best labor practice. 2, whether the claimant is entitled to the relief sought against the defendant in the circumstances of this case. Counsel submitted on issue 1 that the claimant's dismissal violated section 36(1) of the 1999 Constitution of the Federal Republic of Nigeria as amended, which guarantees the right to a fair hearing, and in the same that it is the National Industrial Court that is empowered with exclusive jurisdiction over labor matters, including unfair labor practices, see section 254C of the said Constitution. Learned counsel submitted that the claimant was handed over to the police for alleged fraud, conspiracy, and altercation before being given alteration. Before being given a fair opportunity to defend himself before the disciplinary committee. The disciplinary committee's report later contradicted the initial allegations, finding no direct evidence linking the claimant to fraud but dismissing him for password compromise. Counsel further submitted that the claimant was suspended without pay for 6 months and detained by the police before the disciplinary process was concluded. It is the contention of counsel that the defendant failed to provide credible evidence from the employee handbook or disciplinary policy to justify the dismissal procedure. The allegations of fraud were unsubstantiated, and the disciplinary committee's report exonerated the claimant from dismissal from criminal wrongdoing. Counsel submitted that the dismissal breached the claimant's employment terms and international labor standards. The defendant's actions, including the police before internal disciplinary proceedings, were deemed irregular and prejudicial. Counsel referred the court to the case of Bernard Longe against First Bank of Nigeria, citation provided, where the Supreme Court frowned at irregular procedure in the termination of employment. Olatunbosun against NASA Council, citation provided. Council went on to emphasize the necessity of fair hearing and proper procedure in employment disputes. It is the submission of counsel that the claimant seeks the court to set aside the dismissal, urging it was procedurally flawed, lacked evidence, and violated constitutional and labor rights, especially without adhering to the conventional way of paneling procedure and proceedings. On issue 2, learned counsel submitted on this issue that the claimant argued that the defendant admitted in its statement of defense that the dismissal was based on allegations of fraud, conspiracy, and password breach. Since the defendant made these claims, the burden shifts on them to prove the allegations, which they failed to do. Counsel referred the court to the case of Jibrin against military administrator, Kwara State, to the citation provided, and also Odunsi against Bambala, citation provided, and posited that the defendant counterclaimant has not proved any of the allegations against the claimant, on the basis of which urged the court to so hold. Counsel submitted that the defendant accused the claimant of fraud and password compromise, but provided no concrete evidence. The disciplinary committee's report did not find the claimant guilty of fraud, yet he was still dismissed and even before then suspended without pay for 6 months, by which he was made to go through pain for not just cause. Counsel maintained that suspension without a fair hearing violates labor standards. Counsel referred this honorable court to the case of Garba against University of Maiduguri, citation provided, and posited that suspension is a serious disciplinary measure. Counsel further submitted that the claimant was suspended and handed over to the police before facing the disciplinary committee, denying him due process. No evidence like customer complaints, transaction records, and that was presented to substantiate the fraud claims. The password sharing allegation was contradicted by the claimant's testimony that sharing passwords was a common practice among staff. It is the contention of counsel that Section 36 of the 1999 Constitution guarantees fair hearing and prohibits punishment without proof. The defendant's actions like police involvement before internal discipline was pursued were arbitrary and prejudicial. Counsel submitted that the claimant requests the court to declare the dismissal wrongful, order payment of withheld salaries during the 6-month suspension, and dismiss the claimant's counterclaimant and the defendant counterclaimant unsubstantiated allegations and as hearsay. Counsel cited the case of Ute against the state, citation provided Ladoja against Ajimobi, and others, citation provided. Counsel contended that the defendant made its allegation mala fide and intentionally denigrate and malign the character of the claimant. There was no evidence whatsoever, whether direct or circumstantial, upon which the court can be invited to find in favor of the defendant. This court is urged to dismiss the allegation as unfounded and grant all the relief sought by or against the defendant. The relief, I take that one again. This court is urged to dismiss the allegation as unfounded and grant all the relief sought against the defendant. Reply on points of law. Counsel for the defendant filed reply on points of law on the 15th day of May 2025 and submitted whether an employer must wait for a criminal prosecution's outcome before disciplining or dismissing an employee for gross misconduct involving criminal acts. Counsel further submitted that there is no need for prior criminal conviction. Employers can dismiss employee for gross misconduct even if it involves criminality, without waiting for a court verdict, provided fair hearing is observed. The claimant admitted to sharing login credentials can be gathered from Exhibit DX1, which the defendant claims facilitated fraud. Counsel referred the court to the cases of PC Mike Eze against Springbank PLC, citation provided, where the Supreme Court has maintained that it is no longer the law that where an employee commits an act of gross misconduct against his employer, which has elements of criminal offense under any law, the employer has to wait for the outcome of the prosecution of the employee before proceeding with the disciplinary aspect. Employees need not await police prosecution before dismissing for gross misconduct. See Yusufu against Union Bank PLC, citation provided, where it has been the law, which is no legal requirement for a criminal trial before disciplinary action. Also in Afribank, Nigeria Limited against Osinsinaya, citation provided in Atadi against UBN, where Obadina JCA reiterated that employers can dismiss for gross misconduct or dishonesty if fair hearing is given. Counsel maintained that the defendant followed due process, issued a query to the claimant, allowed him to respond to as per Exhibit DX1, and conducted a disciplinary process before the dismissal. Counsel contended that gross misconduct justifies dismissal. Counsel referred the court to the case of Cooperative and Commerce Bank against Wunko, citation provided as per ONU JCA, as then he was, where it was held that acts like willful disobedience, fraud, dishonesty, harmful to the employer's business are grounds for summary dismissal without criminal conviction. Counsel urged this honorable court to dismiss the claimant's case and uphold the defendant's counterclaim. I will now move to my decision. I have carefully read through the processes filed and also listened to the evidence as well as the arguments presented on the formulated issues by counsel on both sides. The issue that will be all-encompassing in determining this case, in my view, is simple. Hence the following. One, whether the claimants dismissal was unfair and contrary to labor best practices. Two, whether the claimant is entitled to the relief sought. Three, whether the defendant's counterclaim is meritorious. The grounds of the claimant's case is that he was hired by the defendant bank as a financial core banking and IBM WebSphere application expert with employment letter dated 11th of December 2018, and on the 8th of June 2021, he was arrested at work based on the allegation that his domain login was linked to unauthorized modification of customer phone number, suspected involvement in fraudulent withdrawals and password compromise. Claimant was interrogated by the bank's audit team and later by the police based on the report of the defendant. The claimant contended that he was suspended immediately after his release from police custody on 11th June 2021. A disciplinary proceeding followed against the claimant by the defendant. The hearing was held on 27th August 2023, during which the claimant alleged prejudgment by the bank, whereby he was treated as a common criminal. No evidence of fraud was found. The claimant only admitted to sharing his password with colleagues. Claimant averred that he was suspended without pay for 6 months before being dismissed. Claimant stated that the bank acted in bad faith, filed a police petition prematurely, withheld salaries unjustly, and ignored lack of direct fraud evidence. The law has always remained same that in proof of the alleged wrongful dismissal, the claimant in the instant case owes the task to plead the terms and conditions of his employment and to show how they have been breached and who breached same. See the cases of Odoniboye Obu against NNPC, citation provided. Olorun Toba Oju against Abdurrahman, citation provided. And Aforishe against NGC Limited, citation provided. John Hold against Nzeribe, citation provided. Claimant in his bid to found his claim with a view of discharging the burden he bears, presented among others his offer of employment, that's Exhibit CW5. The claimant stated that he was arrested by police on the 8th day of June 2021 before facing a disciplinary panel on the 27th of August 2021, violating due process. The defendant maintained that it followed internal procedure by issuing a query being Exhibit DX1 and conducting a hearing. Section 36, sub 1 of the 1999 Constitution guarantees the right to a fair hearing in disciplinary proceedings. The National Industrial Court Act and also Section 254C of the Constitution of the Federal Republic of Nigeria 1999, as amended, empowers this court to adjudicate labor disputes, including unfair dismissal. The defendant's initial police involvement before disciplinary proceedings tainted the process, rendering it procedurally flawed. While employers need not await criminal trials, fair hearing must precede punitive actions and absolute adherence to the rule, which is sacrosanct under the Constitution. The claimant's admission to password sharing as in Exhibit DX1 did not absolve the defendant of his duty to conduct a fair and unbiased investigation. In the instant case, the claimant was suspended for 6 months without pay, which the defendant claimed to be justifiable under the guise of no work, no pay. It is, however, pertinent to note that while suspension is a lawful disciplinary tool or measure, withholding salaries for an extended period without conclusive proof of misconduct is oppressive in the realm of labor law and employment matters. The defendant failed to demonstrate how the suspension aligned with labor best practice. In law, once parties of their own free will once parties in their own free will and volition enter into a written agreement, they should be in law bound to honor and be bound by the terms of the agreement. And therefore, their relationship and subsequent disagreements must be resolved in accordance with the agreement. And the court cannot go outside the terms is agreed upon by the parties. It was held in Ahmed against CBN, citation provided, that parties are bound by the terms of their contract, and the court cannot read into such contract what was not within the contemplation of the parties, except where fraud, duress, or misrepresentation can be established. It is therefore instructive to add that the terms of contract between the parties are clothed with some degree of sanctity, and if any question should arise with regards to the contract, the terms in any document which constitute the contract are arguably the guide to its interpretation. It is not within the purview of the court to rewrite a contract for the parties. See Minaj Holdings Limited against Amcon, citation provided. The court, therefore, in determining whether there has been a breach of that contract, are enjoined to confine themselves to the plain words and meaning derived from the document. See Oyamenda against Abdul Rahman, citation provided. Exhibit WB8, which is the disciplinary committee report of August 2021, ordered for the dismissal of the claimant, of which he was summarily dismissed via Exhibit C7 for gross misconduct for fraudulent transfer of funds from customers' account. In view of the counterclaim in this case, the defendant provided no direct evidence linking the claimant to the 32,650,000 being the subject matter of the fraud. It was only password compromise, which no evidence of fraud is established by Section 131(1) of the Evidence Act 2011. The law is to the effect that it is the duty of the party who alleges to prove. See VP Industries Limited against Coca-Cola Industries Limited citation provided, where it was decided that the burden of proof is in all cases rests on the person who asserts. Now, arising from the allegation of fraud that led to the dismissal of the claimant in the recommendation of the disciplinary committee, it is apparent that the claimant was not properly treated. I need to underscore the fact that the most important aspect in a disciplinary hearing is that it must be conducted fairly according to the rules. To be able to do this, the employee is entitled to know the nature of the charge against him or her in order to be able to prepare for it in the case. He or she should also be given the opportunity to state his or her case, no matter what the circumstances are. It is not essential that he should be present in person without the hearing. See Nteo against University of Calabar Teaching Hospital citation provided. There is no evidence of the proceedings of the disciplinary committee where the claimant and the persons in attendance or any other witness had interfaced and interrogated each other. Although the defendant had pleaded in its statement of defense that it can dismiss the claimant and suspend the claimant without pay, I have not been able to see any evidence, orally or documentarily, in support of that contention before this court. I find this counterclaim as well by the defendant to be mere saying. Needless to say that pleadings without evidence in support go to no issue. The court reaffirms that while employers have the right to dismiss for gross misconduct, due process and fair hearing are sacrosanct. The defendant's failure to adhere to these principles of fair hearing render the dismissal of the claimant wrongful. The claimant's reliefs are being granted in parts. The dismissal is declared wrongful for violating fair hearing. This relief succeeds, and I so hold. Relief B succeeds to the extent that it is hereby declared that the letter of dismissal dated 17 November 2021, which the defendant issued to the claimant, is contrary to the provisions of fair hearing as provided for under the 1999 Constitution of the Federal Republic of Nigeria as amended, and in particular, Section 36 sub 1 of the sub 1, and even rules of natural justice. Before I conclude on this aspect of the law, let me take a look at what fair hearing all entails. The Court of Appeal in Bioface Enterprises Limited against NDIC, citation captured, held that the standard of fair hearing requires the observance of the twin pillars of the rules of natural justice, namely, audi ultra partem, that is to say, hear the other side, and nemo judex in causa sua. That is, no one should be a judge in his own cause. That is to say, both parties must be given every opportunity to be heard in their respective cases and respond to each other's cases where necessary. Now, looking at the procedure taken by the defendant in the proceedings in the procedure leading to the dismissal, in the proceedings leading to the dismissal, of the claimant, can it be said that there is fair hearing? I doubt if there is. Accordingly, the dismissal is hereby set aside. In consequence, the dismissal is hereby commuted to termination, and I so hold. Relief C is for the sum of 20 million naira for exemplary and aggravated damages. Generally, exemplary damages are damages on an increased scale over and above special, actually, or ordinary damages. It is only awarded in aggravated circumstances and are punitive in nature, so as to address proven acts of recklessness. Thus, damages are punitive or exemplary when they are awarded by way of punishment of the defendant or as a deterrent and are for atonement for the claimant's loss. In GKF Investment Nigeria Limited against Nigeria Telecommunications Limited, citation provided, the Supreme Court, per Obuagu, JSC, stated inter alia, thus, and I quote, exemplary, punitive, vindictive, or aggravated damages where claimed are usually awarded whenever the defendant's conduct is sufficiently outrageous to merit punishment, or where for instance, it discloses malice, fraud, cruelty, insolence, or flagrant disregard of the law, and the like, end of quote. In law, therefore, exemplary damages are damages awarded in addition to actual damages when the defendant had acted with recklessness, malice, or deceit. They are specific damages by way of penalizing the wrongdoer or making an example to others. See the case of First Bank of Nigeria PLC and others against Boniface Chukwu, citation captured. The exemplary damage is not awarded as the claimant failed to. I take that one again. The exemplary damage is not awarded as the claimant failed to prove oppressive conduct or statutory authorization. See the case of Obinna against Commissioner of Police, citation captured. As for aggravated damages, the law is tried that where a breach is being established, general damages will follow without need to specifically plead or prove the damages. See the cases of SPDC Limited against Afinotun and others, citation provided. The converse of which is that where the court finds otherwise, the party is not thus entitled to any damages. This court have held earlier in this judgment that the defendant did not breach the contract of employment. As for the aggravated damages, there is no evidence of malice or injury to reputation. See also the case of Marine Management Associates against NMA, citation captured. The claimant is therefore not entitled to any damages in that regard. Accordingly, claimant's relief C fails and I so hold. As for relief D, the tenor of this relief and the argument presented tend to rely on general costs awarded by court in the course of proceedings governed by Order 55 of the National Industrial Code of Nigeria Rules, Civil Procedure Rules 2017, that sort of cost is not required to be pleaded, as it is left for the court to assess and award. See Tukura against Government of Gongola State, citation captured, where the Supreme Court emphasized that costs should serve as a partial indemnity to the successful litigant. The claimant is entitled to costs in the sum of 200,000 naira. The defendant is hereby ordered to pay the claimant the sum of 200,000 naira cost. This relief succeeds and I so hold. Therefore, for the avoidance of doubt, as for the defendant's counterclaim, they are merely speculative. The defendant sought for 32,650,000 naira restitution for customer losses. B, 30 million naira damages for reputational harm. C, 5 million naira legal costs. The counterclaim is hereby dismissed for lack of credible evidence. Judgment is accordingly entered.
As the court pleases.
The court pleases. Most obliged, my lord.
Very well.
Counsel for the claimant, my lord, we are most grateful for the kind and well-considered judgment.
Very well.
Thank you, my lord.
As the court pleases, as counsel for the defendant, my lord, we are most grateful for the judgment.
Yes, well done. Thank you very much.
Yes, sir.
Most obliged, man. Yes,
enjoy the rest of enjoy the vacation as well.
As the court pleases. Most obliged, my lord.
Yes. We will forward this copy of this judgment practically through the registry of to the register of this court.
As court pleases.
Yes.
Most obliged, my lord.
Ibrahim, we can call the next case.
Suit number NICN/AB/14/2024 between First Bank of Nigeria Limited against Mr. Omotosho Matthew Pelemo.
Yes.
My lord, parties are absent.
Yes.
And both parties were duly informed of today's sittings.
Yes. Appearance. Is there any appearance?
Very well, sir. May it please honorable court, I am B.C. Nwoye. Your lordship, sir, I appear for the claimant. We apologize for absence of the representative of the claimant from today's proceeding.
Very well. No appearance for the defendant. This case is for judgment, and my judgment is ready, and I'm going to read it right away.
I'm most grateful, sir. Court pleases.
Judgment. The claimant applicant, by way of motion on notice dated and filed on the 29th day of October 2024, which motion is brought pursuant to Order 16, Rule 1, and Order 17, Rule 1 of the National Industrial Court of Nigeria Civil Procedure Rules 2017, and under the inherent jurisdiction of this honorable court. The motion prays for the following. 1, an order entering summary judgment of 25,981,828 naira 69 kobo, being the outstanding and unpaid balance of the staff personal loan against salary as at 29th June 2023, given to the defendant while he was an employee of the claimant and as a consequence of his employment with the claimant. 2, interest on the said sum of 25,981,828 naira 69 kobo at the rate of 13% per annum, being the agreed interest from 30th June 2023 until judgment, and thereafter at the rate of 10% per annum until the entire sum is paid. 3, and for such order or other orders as this honorable court may deem fit to make in the circumstances. The grounds upon which this application is predicated are not stated by the council. However, the application is supported by a 27 paragraphs affidavit deposed to by one Abayomi Akambi, male, Nigerian, and a recovery officer with the claimant. The claimant attached 10 annexures referred to as Exhibits AA1 to AA10. In compliance with the rules of this honorable court, the application is accompanied by a written address of counsel wherein a loan issue for determination was formulated, to wit, and I quote, whether the circumstances of this case justify the entry of summary judgment in favor of the claimant stroke applicant, end of quote. On 10th July 2025, When this motion came up for hearing, counsel for the claimant submitted before this court that this motion on notice dated the 29th day of October 2024 and filed same day was duly served on the defendant respondent, and that the proof of service is before the court. Counsel drew the attention of this honorable court that even for these particular proceedings, there is proof of service of hearing notice on the defendant, which proof was filed in the court. It was at that stage that this court has ascertained that there is proof of service of the originating process, motion on notice, as well as the hearing notice on the defendant, to which the defendant neither filed any response nor appears in court, consequent upon which the applicant was then directed by this honorable court to proceed to taking this application. The claimant's counsel, while arguing his application, adopted his written submission in the written address as his argument and urged this honorable court to enter a summary judgment for the claimant as prayed. Submission of applicant's counsel. It is the submission of counsel while referring to Order 16, Rule 1 of the rules of this honorable court and the principles of law by the Court of Appeal in Amadi against UBA, citation provided, and General Tires West Africa Limited against Spring Bank PLC, citation provided, as well as the Supreme Court decision per Mohammed JSC in UBA against Jargaba, citation provided, that the object of summary judgment procedure is to obtain quick judgment when there is no defense to the action, as the procedure is similar to the undefended list procedure designed to obtain judgment, especially in a liquidated demand case, without the need for a full trial where the party cannot satisfy the court that it should be allowed to defend the action. Counsel went on to submit that by a letter dated the 21st of September 2011, the claimant availed the defendant the staff personal loan against salary in the sum of 2 million naira for a tenure of 48 months with an interest rate of 13% per annum. The defendant accepted the loan and utilized them. Counsel referred this court to the depositions in paragraph 6 to 9 in the affidavit and exhibit AA 1 to AA 3. Counsel posited that the defendant responded voluntarily resigned his employment with the claimant with effect from 16th April 2012, and that as at date the defendant resigned his employment, the defendant was owing the claimant the sum of 7,992,409 naira 64 kobo. And counsel referred to paragraphs 12 to 15 of the affidavit in support. Counsel further submitted that as a result of the failure of the defendant to pay the outstanding balance of the loan as and when due, the claimant solicitors demanded for payment of the outstanding debt. Counsel drew the attention of this honorable court to paragraph 17 to 21 of the affidavit, as well as exhibits AA 7 to AA 9, and further submitted that the entire claim of the claimant is based on the refusal of the defendant's respondent to pay the sum of 25,981,828 naira 69 kobo, being the outstanding sum of money owed by the defendant as at 29th June 2023, and that as it is in the instant case, the defendant has no defense on this premise. Counsel urged this honorable court to enter judgment summarily without subjecting the claimant to rigors and expense of trial. The court decision. I have carefully read through all the processes filed by the counsel. I have also listened to the arguments of counsel while adumbrating on his written address, I am of the humble view that the issue that will be best in determining this matter is whether the claimant is entitled to summary judgment. Summary judgment procedure, which is akin to undefended list procedure, envisages a situation where a party in a suit can obtain judgment, especially in cases of liquidated money demand, without the need for full trial, where the other party in the suit cannot satisfy the court that it should be allowed to defend the action. In exercising the discretion of granting or giving a summary judgment, the court is enjoined to examine the statement of facts, the affidavit, and the supporting documents to decide whether or not the claimant is entitled to the grant of summary judgment against the defendant. See Zakem Oil Services Limited against Art in Services Limited, citation captured, and UBA or citation captured. In UBA and another against Alaji Babangida Jargaba, citation provided, it was held by the Apex Court that summary judgment is a procedure for disposing with dispatch cases which are virtually uncontested. It also applies to cases where there can be no reasonable doubt that a plaintiff is entitled to judgment, and where it is inexpedient to allow a defendant to defend for mere purpose of delay. It is for this kind of judgment that the court will consider the contents of the pleadings, the motion, and the evidence adduced. This will allow for speedy disposition of the matter without need for full trial. In this regard, I consider the position of the case in Green Tech Limited and Access Bank PLC, citation provided, as well as CA Akpan against AIP and Investment Company Limited. Where citation provided. The relevant provisions for summary judgment under the rules of this honorable court, that is Order 16 Rule 1, which provides, and I quote, where the claimants believe that there is no defense to the claim, an applicant for summary judgment supported by an affidavit stating the grounds for the belief shall be filed along with the origination process. The application shall be accompanied with the statement of facts, any exhibits, and a written brief, end of quote. Now, in the instant suit before me, instituted by the claimant, dated and filed on the 27th of October 2023, wherein the claimant primarily claims for the sum of 25,921,828 naira 69 kobo, as well as 13% prejudgment and 10% post-judgment interest, which has remained unpaid by the defendant respondent and who has allegedly admitted to the indebtedness. The defendant on his part, did not dispute service of the defendant's processes and also did not deem it fit to file any process or even appear in court to put up his own defense. It is tried law that a party has a right to be heard in a trial, but such right must be confined to circumscribed limits and not to be allowed to run wild. See the case of Aderemi Adedamola Ajidahum against Mrs. Dauphine Oteri Ajidahum, citation provided. The Supreme Court has decided in Abi Miami Brick and Stones Nigeria Limited against ACB, citation provided, that a defendant who has been duly served with all the originating processes and hearing notices, and without any justifiable reason, refuses to react to the case of the claimant against him, cannot be heard to later complain of lack of fair hearing. By the provisions of Order 16, Rule 5, Sub 2 of the Rules of this Honorable Court, it is provided that where it appears to the court that a party does not have a good defense, the court may thereupon enter judgment for the claimants. In the instant case, the defendant has failed to enter defense despite proof of service of the necessary processes and also hearing notices on him as can be gleaned from the case file before this Honorable Court. Therefore, this court will now proceed to determine the entitlements or otherwise of the claimant from the relief sought, as it is tried that the success of a claimant's case is hinged solely on the strength of the claimant's case and not on the weakness of the defendant's case, even where the defendant did not lead evidence. See the case of Action Congress of Nigeria against Nyako, citation captured, and Healthcare Products Limited against Bazaar, citation is well captured. Also, it is the law that a claimant will not be entitled to judgment merely because the defendant abandoned its case by failing to lead evidence in support thereof, as courts of law are always bound by the unchallenged, uncontroverted, and unrebutted evidence led by the claimant, if such evidence is cogent or credible. See Arewa Textiles PLC against Fantex Limited, citation captured. In the instant case involving both the originating process, and the motion on notice, there has not been any response by the defendant, as I earlier noted above. The only materials for the court to look at are those that are filed by the claimants. It is tried law that where facts are not specifically denied or depositions not counted, they are deemed admitted for all intent and purposes. See Aridola Okoye Trading Company against Bank of Credit and Commerce, Inri 1, Omoleg G 2 NDIC, citation provided. I agree with the submission of the Learned Council that in a situation like this court is enjoined to only consider contents of the affidavits and additional evidence, such as the exhibits attached to deliver a judgment summarily without the need for trial, as initiated in the case of Unko Market Community Bank Nigeria Limited against OB, citation provided. I find that the amount being claimed by the claimant is clearly outstanding and never contested. This is deducible from the letter of demand, from the payment of the letter of demand for the payment of the outstanding balance of the loan in the sum of 25,981,828 naira 69 kabu. The said letter was delivered to the defendant. More so, the statement of account was also delivered to the defendant, which was never queried by the defendant. This, in my humble view, reveals that the defendant has admitted his indebtedness to the claimant. The law is stated in Tilly Gado and Company Nigeria Limited against Access Bank, citation captured, where it was held, where a bank makes demand for settlement of a debt by letters, and the amount of the debt is contained in each letter, and the debtor does not query the respective figures written in the letters as the overall debt due. The debtor will be deemed to have impliedly admitted the queried the quoted figures as the amount of the debt. The claimant has put in the statement of account, which is also served on the defendant in this matter, and the defendant has not disputed the said statement of the account. In this extent, the Court of Appeal in Oceanic International Bank against Brookfield Agro-Allied Industries Limited, citation provided, held that the usual way of proving a debt, the usual way of proving a debt by a bank is by putting in the statement of account or secondary evidence thereof where it is admissible. These documents are attached to the affidavit and also front-loaded in the substantive suit before me. The Supreme Court in Zeribe against Dev Engineering Company Limited, citation provided, held that where evidence given by a party to a proceeding or his witness is not challenged by the opposite party who has the opportunity to do so, it is always open to the court seized of the proceeding to act on the unchallenged evidence before it. This is so because in such circumstances, the evidence before the court obviously goes one way with no other set of facts or evidence weighing against it. There is nothing in such a situation to put on the other side of the probable imaginary scale or balance as against the evidence given by or on behalf of the plaintiff. The onus of proof is in such a case, is naturally discharged on a minimum proof. I have painstakingly examined the evidence before me. I have found that the crux of this case is for the recovery of the sum of 25,981,828 naira 69 kobo being the outstanding and unpaid balance of the staff personal loan against salary, which was given by the claimant to the defendant, which he was an employee of the claimant, and as a consequence of his employment with the claimant. I also noted that claimant seeks for a 13% pre-judgment interest over the sum of 25,981,828 naira 69 kobo and 10% per annum post-judgment interest until liquidation, while at the same time, cost of this action assessed at 500,000 naira. Reading through the paragraphs of the affidavit in support of the motion, it is crystal clear that the relationship between the claimant and the defendant is intertwined and shrouded with all formalities for the creation of lawful contract, and each party is bound to discharge its own obligation without any breach. And this court is by this suit called upon to guard against the wrongdoing. The law is as stated by the Court of Appeal in the case of MTN Communication Nigeria Limited against Sadiku, citation captured, that where there is a wrong, there ought to be a remedy. Once the court is satisfied that a person has suffered a legal injury, it will surely be provided with a remedy. From all that have been said above, it suffices to say that the claimant herein is entitled to relief 1 in this application. Accordingly, this relief is granted. Relief 2, on the face of the motion paper, is for 13% prejudgment interest against agreed upon from 30th June 2023 until judgment, and thereafter at the rate of 10% per annum until the entire sum is paid. It is my humble view that by its very nature, this is a staff personal loan against salary, which is repayable over a period of 48 hours or 48 months, having been disbursed on the basis and strength of Exhibit AA1, AA2, AA3, and AA4. However, in the course of the employment of the defendant with effect from 16th April 2012, see paragraph 6 to 13 of the affidavit in support. This shows that the amount is liable to an interest that was earlier agreed upon by the parties. The amount could stand as at the agreed interest of 13% from 30th June 2023 until this judgment, I so hold. However, with regards to the 10% post-judgment interest sought for by the claimant, there is no document showing the extent thereof, to which I can grant. In this regard, I decline to award the 10% post-judgment interest as paid. Flowing from all said above, and for the avoidance of doubt, relief 1 of this motion paper succeeds, while relief 2 is partly granted only to the extent that 13% prejudgment interest from 30th June 2023 till judgment, while the relief seeking for 10% post-judgment is hereby refused. Ruling is accordingly entered. This is the ruling of the court.
As the
The
court
court
pleases.
pleases. The Lord, we are most grateful for a well-deserved decision of this honorable court, and wish my
Very
Lord
well.
a fun-filled vacation period. We are most grateful, sir.
Very well. Yeah.
That will be all, my lord.
Very well. Okay, we can now leave.
Thank you very much, sir. Most grateful.
Very well. Enjoy the rest of the day. Yeah. Are you going back to, are you based in Abeokuta?
No, sir. I'm in Lagos. We usually come from Lagos to Abeokuta.
Oh, you do follow us to, we go from the same direction.
Very well, sir.
Ah, very well. You are doing a lot of things over there.
Well,
Yeah,
that's what we came to. What we signed us, sir. I'm most
very
grateful.
well. Okay,
Do
thank
enjoy
you.
your vacation.
Thank you so much. Ibrahim?
Yes, my lord.
Yeah, I did not see the rest of your team like Omotayo and Delapo. Why are they?
They are around, my lord.
Oh, I did not see their faces.
Yes, my lord.
Eh?
They are around,
Okay.
sir.
Very good.
Yes,
Well
sir.
done. Now we can leave.
Yes, my lord.
Thank you. Mm. Hmm? Mm. That's what I'm judging.
Most grateful.